right. Well, we're going to move right. You know, we do Emma. We educate, we motivate, we mobilize, and we agitate. And we're in that educating mode. And we have our very, very well learned lawyer here, Mr. Corey Beckles. And have you been learning a lot from him? People are messaging me. Even tonight, people messaging me. People, we are learning so much from Attorney Corey Beckles. Let me use this opportunity to welcome you, sir. Welcome to the Marcia Week Show. You're muted, sir.
Yes, good evening.
Good
Marcia,
evening. Yes,
thank
sir.
you for having me.
It's a pleasure. It's a pleasure. We are ready. Look, I got my notebook here. I just took notes on those rodents, and I'm ready now. I'm ready for the rights of beneficiaries, estate without will.
Right.
Yes.
Okay. Very good.
We ready.
All right. So I'm not certain how much how much information persons remembered since last Monday. I may have to start giving some homework. Or some tests.
Yes, we need to get homework.
Right, because it's a lot of information.
Yes.
Right, and it's very important that we take note of everything. But this evening, we're talking about the rights of beneficiaries again. Last week, I spoke about the rights of beneficiaries when there is a will. So now, I will be speaking concerning the rights of beneficiaries when there is no will. So when there is no will, when a deceased does not leave a will prior to their death, that is referred to as dying intestate. So we have dying intestate when you leave a will, but when you do not leave a will prior to your death, you die intestate. And the beneficiaries of that deceased individual will have to apply to the court for an application or make an application to the probate registry called an application for letters of administration. Now, which is different to an application to probate a will. Because when we have a will, we have the name of an executor, the person who is going to take over, who is going to make sure that the contents of the will are carried out. Yes. That is the executor. But when there is no will, then there's really nobody, there's no one that has been named. There's no one that the deceased has chosen that the beneficiaries can look at and see, well, this is the individual that will take over the management of the estate. So in that event, we have to look to see who are the family members of the deceased individual. And if the deceased has a spouse, the spouse is the beneficiary. That's one beneficiary when that deceased individual dies without a will. We have the spouse, we have children, we also have the parents. So I want us to take note of this. Spouse, children, parents of the deceased, and we also have the siblings of
So let me ask you a question. Is it in that order that the courts look at it in that order?
Right, yes. So the Succession Act. The courts will follow what is written within the law. And the law refers to the beneficiaries or to those individuals.
Yes, he's stuck, but he usually gets unstuck soon. In the meantime, guys, go ahead and share. Yes, you're back. Go right ahead.
Yeah, the categories of those individuals is the spouse. So you'll find this written in our law. The spouse, we have the children, and then we have the parents or the siblings of the deceased. Of course, and we call this you mentioned the order. We call this the order of priority. The order of priority. So spouse, children, parents, siblings. If there is no such individuals who are alive, then we go down the line. We keep going down. So whenever you are making that application to the probate registry for letters of administration, usually the spouse of that deceased individual has the priority to make the application. After the spouse, then we have the children.
Mm-hmm.
After the spouse, we have the children. But in some jurisdictions, we have the spouse. Then we also have if there's no children. So everything is based on who is alive
Right.
when that person is no longer with us.
So let's go over again. So spouse, the children, then parents, then siblings. Yeah.
Then siblings.
Yeah.
Right. So, and we're talking about the rights. We will get into some more aspects of the beneficiaries. What is the shares, the amount of shares or portion that each beneficiary will receive. But as it relates to the rights of the beneficiaries, it is very important that you know whoever is making the application, they must know which place or which position in the priority they are in. Now, let's say we have a spouse and children. If you have a spouse and children who are still alive after the deceased passes away, the parents are not part of, they cannot benefit. As long as we have spouse and children, then a portion goes to the spouse and a portion goes to the children. As long as there is a spouse, as long as there are children, then we don't even speak about the parents. We don't even speak about the siblings.
Mm-hmm. Mm. Very interesting.
If there is a spouse but no children, then we go to the parents of the deceased. And sometimes you may not be, the parents of the deceased may not be alive. So then that is how we go to the siblings. So if there is a spouse, no children, then the spouse will inherit and also the parents will inherit. If there are no parents who are alive, then the spouse and the siblings will inherit the estate of the deceased. And we're still talking about the rights of the beneficiaries when a person dies intestate. And this is important because I know that persons speak a lot about the importance of wills and making wills. The law will determine if you do not make a will, the law will determine what or who your property goes to, depending on the situation, the family dynamics, the family situation, who is alive. The law will determine
The
who
law
your
is going to do
property goes to. That is why it's very, very important that you decide before you leave this world. You make a decision what you want to do with your property and who you want to give your property, your assets to.
But Mr. Beckles, say for example, a wife and husband, they live together, they don't have any children, the husband passes. It is understood then, based on what you're saying to me, that what he's left, if he has no will, is left to the wife.
Yeah, that is the general understanding. And you will have situations where even the parents, if they're still alive, and the siblings, they will recognize, well, everything should go to the wife. But that is not what the laws of Barbados say. Because the laws of Barbados also give, when there are no children, a spouse and no children, the laws of Barbados give the parents or the siblings, as the case may be, the opportunity to benefit from the estate of their deceased relative.
So they can demand.
They can basically demand. So we're talking about the rights of beneficiaries. They can actually demand an interest in the estate, right? So, and this is very important because we have a spouse, and spouse is grieving. Spouse is really not even thinking about the rights of beneficiaries. They're not thinking that the parents or even the siblings may inherit the asset. The main asset usually is the house or that matrimonial home. Now, there are other issues, legal issues, that will come into play So let's say that the house was acquired by both the husband and the wife.
Mm-hmm.
Now, if it is acquired by both the husband and the wife, it means we go back now to what we learned as joint tenants. If it is joint tenancy as it relates to the property, now we know that the survivor takes the full ownership of the property. So the siblings or the parents or any interest they may have does not come into play when we're dealing with joint property.
Right. You did that last
Right?
time. Yeah.
Right. But there are situations where the property is not a jointly owned property. There are situations where the property is in the deceased name alone. Now, this is what causes issues in settling estates. Because, as I said, once there's no children, the spouse who is alive, yes, will receive a benefit, but parents and siblings, as the case may be, can also come into the mix, and they would normally write a letter or let the spouse know, well, we want to receive what belongs to us, right?
Okay.
And that causes issues in and of itself.
I can imagine. You let me know when you want any questions from the audience, but I believe you
Yeah,
have one.
as the questions come, just let me know,
Okay, well,
and I
there's
will
there's
answer.
one here from a Joanne Roberts.
Right.
She says, if you were given a deed of gift, you're not married or have children, who will inherit if you die suddenly?
Right. If you're not married, you don't have any children, but you do have family members, right? So the right of inheritance, as long as you die without a will, the right of inheritance depends on which family member is alive when you pass. Whether
Okay.
it's the parents, whether it's the siblings. There is a term that persons usually are familiar with, the next of kin,
Yes.
right? So we are usually familiar with this term, next of kin. So if you're not a parent, if you're not a spouse, if you're not a parent, if you're not a child, if you're not a sibling, if you're not a niece, a nephew, you go down the line. The law determines that there must be someone in your family line. If you can't find the spouse, if you can't find the child, if you can't find the parent, if you can't find the siblings, if you can't find niece, nephew, grandchildren, as the case may be, if there's no one, the usual beneficiaries, if we cannot find those, then the law looks for who is next in line in
Yes.
your family.
Yes.
So
Okay.
you go down the line, the family line, and you look for a next of kin.
Yes.
Who is the closest family member to you? And that individual will inherit.
Yes.
But
And
there's
it
an order of priority.
order priority. Yes. And it Brewster is asking, can a nursing home take your house if it's in a trust?
No, no, they cannot. A nursing home. Well, I am trying to think about any situation where a nursing home will be able to take your home unless you give them the right to your home, or you transfer the home to them.
So, guys, he's stuck. In the meantime, can you like and share? If you're on here tonight and this is you're getting a lot of education through this channel, we're going to ask you kindly to like and share and spread it. Spread the knowledge. All right. Yeah.
Right,
Simple.
yeah. So
Yes. Go ahead.
unless you intend to give the nursing home your property, whether by will, whether by deed of gift, um, it is very difficult for the nursing home to touch that property unless you give them a specific right prior to your passing. If the
Mm,
property is in a trust, then the property is even further secured
right.
or fenced in.
Mm-hmm.
And whoever is, let's say, a third party, in this case, in nursing home will be a third party. Unless you state in your trust that the nursing home has some interest in that property, then I can't envision a
Mm-hmm.
situation where the nursing home will be able to take your home in that circumstance.
Wow. Okay. Somebody is asking, there's another question here. If that's one, when you were talking about how it's apportioned.
Right.
So it's
Yes.
a one third and two thirds of the estate for the spouse and children.
Right. Correct. Yes. So as long as there's a spouse and children, the spouse will take a third of the estate,
Ah,
and 2/3 will be divided between the children.
between the children. Okay. Okay,
Right.
boy,
So the
I did
children
not
will
know that.
receive a bigger portion
Right.
of the estate.
Oh, I didn't know that, sir. I this is I'm
Right.
oh my lordy, this is really good information. There's a question here that Christian is saying, Christian girl Natty says, if a person dies without a will, can a common law spouse be included in the estate? The deceased was not married.
Yes. Yes. Short answer is yes. But for a common law spouse, the spouse, that common law spouse or intended or prospective common law spouse, must be declared to be a common law spouse.
How do you do
Right?
that?
So, yeah, so they must be declared in law to be a common law spouse. And usually that is done by going to court, and the court will make a decision as to whether or not this individual is really the common law spouse of the deceased.
Mm, mm. So they have to establish that. He's stuck. He's stuck. Guys, like and share. Like and share. Okay, thank you, Jacqueline. Jacqueline says she liked and shared on Facebook.
Right.
Like and share. Continue. You got
Right,
stuck,
yes,
so
I'm
just
back. Right, unless the deceased did something to show the world, identify this individual as their common law spouse,
mm-hmm,
the common law spouse the prospective or intended common law spouse will have to go to the court to be declared a common law
mm-hmm.
spouse. Of course, there's no marriage certificate to show or to prove that
Right.
you are the spouse. So in this case, you need a declaration from the court that you
Mm-hmm.
are indeed, or at the date of death of that individual, you were their common law spouse. And to be a common law spouse, you have to be residing with them for 5 years, at five
Okay.
years or more prior to their death. 5 years or more prior to their death. And I see this question here. Don't let me lose this question,
Yes. No, I have it
because
there.
there's another issue as relates to common law spouses. Now, when two individuals are in a relationship, the Succession Act refers to a single man and a single woman residing together as husband and wife for 5 years or more. A single
Mm-hmm.
man or a single woman residing as husband and wife. Everything they're doing tells the entire world, yes, there's they're doing the
Okay,
same
guys.
things.
Yeah. Mm-hmm. So they're doing
Yeah, they're
everything
doing the
together.
same thing. The prospective common law spouse will provide the evidence that they are indeed, um, or they were indeed living as a common law spouse, living as husband and wife with the deceased individual. Right? If there's a will where the children have inherited, can they leave their children their portion? Yes, the short answer to that question is yes. If there is a will where the
Mm-hmm.
children have inherited, can those children leave their children their portion? They
Okay.
can, but it all depends on what the will says. Now, the will may give the property to the children of the deceased as joint tenants. And again, we go to the joint tenancy and the tenancy in common.
Yes.
With a joint tenancy, remember, whoever is the survivor takes the entire portion.
Mm-hmm.
So it is important that if land, property, assets are left
Yes, we're on it. That it's breaking up, and we're just asking you in that time. Just hang on. It's he comes back.
Right,
Relax.
right, yes, yeah, yes. It seems in and out. Right, but we will move forward. Right. So the last thing we're speaking about is the will and joint tenancy. Remember, you have to sever the joint tenancy. You
Mm-hmm.
must sever that joint tenancy. If the will gives the assets to the children as tenants in common, then of course, automatically the children will have the right of inheritance.
Yeah, we're getting some interference here. The internet is cutting out.
Yeah.
Yeah.
Yeah, the amount of work that you will have to do depends on what is written in the will. But just be reminded concerning the joint tenancy and the tenancy in common.
Yes.
That is important.
What exactly what it is? Okay, there is um somebody saying here. There was another question, but oh, what happens when the man leaves the wife and lives with another woman? Lives with her for years and has children from both relationships, but does not divorce the wife. What is going to happen there?
All right, yeah. So we have some a complicated matter.
It's
Now
complicated.
I'm gonna go back from the beginning. What happens when the man leaves the wife, right? So he's separated. So we start with the separation.
Mm-hmm.
Now, if you are separated from your spouse for 5 years or more, that spouse, let's say you die, your surviving spouse cannot inherit. They
Mm.
lose the right of inheritance as long
Five
as you can,
years.
yeah, as long as you can show separation for 5 years or more. The right of inheritance, even for your legal spouse, the, the legal spouse loses the right of inheritance. Right? That is the first thing. And that is something that is very important. The right of inheritance is lost as long as the individuals have been separated for 5 years or more.
That is serious. My God, can you imagine you're with somebody for 30 years,
Okay.
and my gosh, go ahead,
Right,
continue.
yeah. So the issue now comes into play because when that individual has died, they're still not divorced. They're still not divorced. Now, what is going to be interesting is how the law will treat to the individual who the deceased lived with when they die. Remember, as long as 5 years has passed, 5 years or more, the spouse, the legal spouse, loses the right of inheritance. The individual whom the deceased was living with will have to claim to be a common law spouse. She will have to claim, he or she will have to claim that they were a common law spouse. But remember, this individual is still not divorced. Still not divorced. Now, it will be a very not an impossible task, but the prospective common law spouse will have to prove the 5 year period, the five
Right.
year period of separation. They will have to prove that they were indeed living as man and wife for 5 years or more. Of course, they have children, so that also is part of the evidence.
Mm-hmm.
But remember, the law states it must be a single man or a divorced man and a single man, single woman, or divorced man, divorced woman. Now, there is another case, Marcia. There's a very important case that was heard a few years back called Selby and Smith.
Mm-hmm.
We don't have the time to go into that case right now, but next week, God willing, I will
Yes. Yes.
give some more information into that case
Yes.
because that's
We
a
have
very
about five
important case.
minutes right now. 5 minutes. Yeah.
Right, that is a very important case as it relates to divorced individuals, not just divorced individuals. This case really set a precedent as relates to what is the requirement to become a common law spouse in cases such as the question that was
Mm.
asked. And it's very important that we understand what that case said and what it did not say. Very
Mm,
important what the case said and what it did not say. Now, I have some notes concerning the case. I'm going to bring those notes next week.
next week,
So don't let me
yes.
forget, Marcia. Some very, very
Yes.
important notes. Some
It's
very, very
Selby, it's
important.
Selby. You said Selby versus?
Yes, Selby and Smith. Selby, Selby,
Mm-hmm.
against
Smith.
Smith,
Yes,
Smith. And
yes.
this case went from the High Court of Barbados to the Barbadian Court of Appeal to the Caribbean Court of Justice. And the Caribbean Court of Justice made their ruling. And as we know, the Caribbean Court of Justice is our court,
Mm-hmm.
highest court of appeal. So we recognize their judgments, and whatever they say really goes as
Yes,
relates to legal authority.
yes. There is a question that came via WhatsApp. It came actually 7:30 this evening. And I
That
did,
case.
I guess I'm seeing a question that came from someone from overseas actually. Sent
Right.
a question at 7:30. So I have to make sure I don't call their names, but they said, "Good night, please. Can you ask Mr. Beckles what happens when a sibling from a family of 8 dies without a will? There's the estate that comes with a vehicle and bank account." Okay,
Right.
and they want to know what happens. I don't know. You understand the question?
Right. Yes, I understand. So
Okay, okay.
again, it comes down to who is alive, who is the spouse. Remember, we have the order of priority. So we start with a spouse. Is there a spouse? And we come down the line. Are there children? We know that they're siblings.
Mm-hmm.
We know that they're siblings because one of the siblings are present. They're asking the question: are the
Mm-hmm.
parents alive? All of these questions must be answered. If you cannot find any spouse, if you cannot find any children, if you cannot find any parents, if they're no longer with us, then it comes down
Yes, Valerie, this is very good information.
to
And
dice. It all
yes,
depends on who is alive when that individual passes. So
yeah,
it depends on who is alive, Marcia.
depends on who is alive. So it will just go
Depends
down.
on who is alive.
Remember, spouse, children, parents, siblings, right? It goes down the line like that, the order of priority. All right. Okay, there's one last question we can do here. And then we will close until next week. If your parents died and there's no will, but the eldest daughter paid the land tax, is she entitled to the property? That's a big question there for you, Mr. Beckles.
All right, yes. And this is a general principle. Paying the land tax does not give any individual a right or interest or a right of legal interest in a property.
You said
It
that
does not.
last
That
week.
is
You
the
said that before. Go ahead.
right. Yeah, that is the general principle. Paying the land tax does not give any individual a legal right or interest in a piece of property, whether it's land, whether it's house and land. Paying the land tax does not. That is a general principle. If that individual is claiming an interest, then they have to prove more other than paying the land tax. And there's some other things we can get into um, as relates to
Mm,
how do you prove um, ownership.
mm.
Yeah, paying land tax by itself does not give you a right of ownership.
Yes, yes, but you can, as you're saying, as we go on, you'll be able to to give us
All right, yes,
some other,
some
yeah,
other legal principles
legal principles
that
that
come into
can,
play.
right. Well, in your final 2 minutes, what do you want to say? Can you just to wrap up with our audience until next week? It went by so fast.
Right, yes, yes, it always does. And I didn't even get into the practical side as
I know.
relates to the rights of beneficiaries,
Next
as
week.
relates to the notice that must be given to all beneficiaries when a person dies without a will. But I want us to take away, as long as you're a beneficiary, as long as you are, any individual whose family member has died, you must make sure you know where you stand as relates to the order of priority. And it's very important that the beneficiaries know who they are. And if you are a if you're a co-beneficiary, meaning that there are other beneficiaries alongside you, it is very important that you don't run ahead of the other beneficiaries.
Right.
If we have beneficiaries who are on the same level, and this is another principle, if we have beneficiaries who are on the same level, so siblings are on the same level, even though we have the eldest sibling, and the eldest sibling may take over. But in the eyes of the law, they are on the same level. All of them are siblings. And it's very important if the siblings are the main beneficiaries, it's very important that the siblings sit down, speak to each other, and determine what they want to do as
Mm-hmm.
relates to the management and the settlement of the estate. Even if one of them is going to make the application to the court, I can't stress this enough. Sit down and discuss, because at the end of the day, no one beneficiary can run in front of the other legally.
Mm-hmm.
As long as you are a co-beneficiary, you are both, let's say, three individuals, you are all entitled to a portion of the estate. And the law will make sure that you get a portion of the estate. But I find that we have situations where one beneficiary may not be communicating with the other, and then that delays the settlement of the estate, because we know how it is.
Okay. He stopped. Can we go? He's go right back. Yes.
Right, yes, and that delays the settlement of the estate. So remember, you want you want your portion of the estate, but if you are
Mhm.
not communicating, it may become a contentious matter. And at the end of the day, 10 years pass, 20 years pass, and no one receives their portion.
Mm.
It's very important that beneficiaries sit down and discuss as much as you can. Sit down and discuss. If you can't sit down and discuss it, then that is where attorneys come into play. I always advise, even if there are multiple attorneys, let the clients sit down with each other and do alternative dispute resolution.
Mm-hmm.
Try your best not to go into the court system to
Right.
settle
It's,
estate
yeah.
matters
Try it
when it can be settled at a meeting. When it
in
can
a
be
meeting.
settled at a meeting.
Well, thank you so much again, Mr. Beckles. And I just forwarded two persons information your number because they're messaging me. But thank you for
Right,
the
no problem.
education. We appreciate it very much. Yes.
You're
Have a
welcome.
great
I
night.
will I will get this internet connection
Yes.
stabilized
Yes, and I have
for our
something I
next
can tell you
segments.
about. I can talk to you about that. So we have, and I need to remind you about Selby versus Smith for next week as well. So we got homework.
Yes, for next week. Yes.
Yes,
Right,
I
yeah.
know
So we
people say
already have
thank
the
you.
topic for next week.
Yes, and yeah, all right. Thank you so much. Thank you so much, Attorney Beckles. God bless you.
Right. You're welcome. Have a good evening.